Glad that everyone has taken time from their busy schedules to join us for this morning's webinar. Welcome to our University of Louisiana System Bridging the Divide Summer Series. Today's webinar is Unlocking the Potential of Intellectual Property within the University of Louisiana System. I am Cheryl Hall, the 2023 UL System Content Expert in the area of research and grants. Presenting this morning is Attorney Anthony Green, Senior Contract Specialist for American Type Culture Collection, a life sciences company. Anthony has an exceptional skill set. He's a mechanical engineer by trade and education. He served as a mechanical patent examiner for the U.S. Patent and Trademarks Office, a patent engineer for John Deere and Company, a tech transfer strategist for Southern University's Office of Sponsored Programs, and overseas as an IP professional for Saudi Aramco. If you have questions, please place them in the Q&A. Any comments, place in the chat. So without further delay, I turn it over to Attorney Green. Good morning, Attorney Green.
Good morning. Good morning, everyone. Thank you for having me. Thank you to the University of Louisiana System for inviting me. And special thanks to you, Mrs. Hall, for giving me the opportunity to present something that I've been somewhat passionate about for the past 25 plus years. I've been working in intellectual property since 1999. So it's in multiple capacities, as Mrs. Hall just pointed out. So I know a little bit about intellectual property. I won't pat myself on the back and call myself an expert, because there's always someone that knows a little bit more than you. But I think there's something I can share today, excuse me, that hopefully you take away and can use it in your career moving forward. So the title of the presentation today, as Mrs. Hall pointed out, is Unlocking the Potential of Intellectual Property within the University of Louisiana System. The agenda for today, introduction, which is what I just did, the disclaimer, understanding IP, navigating the disclosure process, the differences between inventorship and ownership, understanding technology transfer regulations, and then finally the conclusion. And in the end, question and answers, and have whatever you need to know, whatever you don't understand, definitely raise the question. If it's a particular slide that some information that I covered and you didn't understand it, just jot down the number of the slide and I can always address it at the end. The disclaimer, the information provided in this presentation is for educational purposes only. It is designed to provide an understanding of intellectual property and technology transfer within a university context, and it does not constitute legal advice. Situations involving IP and tech transfer can be unique and complex, and each institution within the University of Louisiana System has its own unique approaches and methods for handling intellectual property and commercializing technologies, which are consistent and in compliance with the University of Louisiana System's Intellectual Property and Shared Royalties Policy and Procedures Memorandum. Therefore, it is crucial that specific questions or concerns involving IP law, strategy, and protection be directed to your institution's technology transfer office and the legal counsel they recommend. Now, in the first section, I want to go into helping you to understand intellectual property. The two sections or two areas within this section that I want to cover in depth are what is IP and types of intellectual property. Now, before I get started, keep in mind that intellectual property when it's in itself is a weeks-long course. And you can't speak about intellectual property without talking about technology transfer, especially within the university context. And technology transfer is a weeks-long course. So imagine I had to take two very in-depth topics and try to combine them into a 1-hour presentation. So I want to give you a very high-level overview of both concepts, but I also want to try to dive into some details as well. According to the University of Louisiana System Intellectual Property and Shared Royalties Policy and Procedures Memorandum, IP is defined as the result of intellectual or artistic activity created by an individual in a scholarly, professional, or student capacity, including but not limited to inventions, discoveries, know-how, show how processes, unique materials, original works, computer software, scientific or technological developments, and other creative or artistic works that have value, regardless of whether subject to protection under patents, copyrights, trademarks, service marks, trade secrets, mass works, and plant variety protection certificates. It also includes the physical embodiments of intellectual effort. For example, models, machines, devices, designs, apparatus, instrumentation, circuits, computer programs, and visualizations, biological materials, chemicals, and other compositions of matters, plants, and records of research. So as you can see, the University of Louisiana system has a very comprehensive definition of what intellectual property is. And if you look at the link that I have below, you can find that memorandum online for your consumption after this presentation. So what are the various types of IP? There are many different types of IP, but there are four main types of IP that you're going to encounter throughout your entire career. There's going to be others, but these are the four main types. The first one is patents. According to 35 USC 101, any person who invents or discovers any new and useful process, a machine, an article or manufacture, a composition of matter, or any new and useful improvement thereof may obtain a patent. This is also known as patentable subject matter. The second type of patent that you may come in contact with, type of IP, that you may come in contact with is a trademark. It's somewhat difficult for me to see. Let me see if I can, yes, I can pull this down, okay. A trademark can be either a word, a phrase, a symbol, or design, or a combination of words, phrases, symbols, or designs that identifies the source of your goods and services, provides legal protection for your brand, and helps you to guard against counterfeiting and fraud. The third type of intellectual property that you're going to encounter in your career is a copyright, which is a form of protection grounded in U.S. Constitution and granted by law for original works of authorship fixed in a tangible medium of expression. Copyright covers both unpublished and published works. There are three main types of requirements for a copyright. It must be original, it must be fixated, and it must be a work of authorship. And I'm going to go into detail on for each one of these types of patents, types of IP. I don't know why I keep calling them patents, types of IP as I move into the presentation. And then the fourth and final type of intellectual property that you may encounter is considered a trade secret. Trade secrets are defined as any formula, patent, compilation, program, device, method, technique, or process that provides the owner a market advantage if kept secret from competitors, and is reasonably expected to prevent others from learning about it absent improper acquisition or theft. So let's dive into patents. So the Patent Office defines a patent as a property right. And one thing I would like to make clear here is that a patent doesn't allow you to, or give you the right to make, use, offer for sale, or import the invention. What it does give you is the right to exclude others from making, using, offering for sale, or selling the invention throughout the United States, or importing the invention into the United States for a limited time in exchange for public disclosure of the invention when the patent is granted. This is called an exclusionary right. Now, the patent system operates on what is considered a quid pro quo system, meaning if the inventor gives something, in exchange, they're getting something in return, which is the limited time or the monopoly that they have for their invention. There are essentially three main types of patents. The utility patent, as I just pointed out in the previous slide, for inventing a new or improved and useful process, machine, article, or manufacture, or composition of matter. A design patent for inventing a new, original, ornamental design. So say, for example, you have an idea for a new table or a new chair, a design for a new table, or a design for a new chair, or a design for a clock. That particular design can be patented at the U.S. Patent and Trademark Office. And then you have a plant patent for inventing or discovering and asexually reproducing any distinct and new variety of plant. Now, as I just mentioned, The quid pro quo is if the inventor shares his invention to the world, that in exchange, the government gives you a limited time. Okay, so what is that limited time? For patent terms, utility and plant patents have a term for up to 20 years from the date of the first non-provisional application for patent that was filed. A design patent is granted for a term of 15 years from the date of grant. So a patent 15 years from the date it was filed, and for a design patent, 20 years from the date it was filed, and for a design patent, 15 years from the date it was granted. So there are 5 main types of requirements for patentability. The first one, patentable subject matter. We just covered that in the previous slide. The second main requirement for patentability is utility, meaning that the invention must be useful. It must provide some identifiable benefit and is capable of use. Perpetual machines, hypothetical devices are not considered useful by the U.S. Patent and Trademark Office. Novelty, that's the third requirement. That basically means it must be new, should be different and distinguishable from anything that is publicly known. Now, the statutory bar requires that the patent item must not have already been in public use or for sale in the U.S. for more than 1 year prior to the date the patent was applied for. The fourth requirement is non-obviousness, and this means that the patent must contain more than obvious differences from the prior art. And prior art is just patents that were already patented that's out there for public consumption. And prior art can be publications, not just patents, but publications, magazines, journals, et cetera, et cetera. And the fifth requirement is considered enablement, and that requires that the applicant give a sufficiently good description of his or her invention. A trade secret. The key to a trade secret is that it has inherent economic value because they are not generally known or readily ascertainable by others, in which the owner takes reasonable measures to keep secret. The key is, has value and is kept secret. Trade secrets are considered a business's hidden gems. They are protected without any procedural formalities related to the laws of a country, and they remain valid as long as the secret is kept confidential. Now, what are some famous trade secrets that you may not be aware of, but you may use the products or the brands every single day? Google's search algorithm, Coca-Cola's Coke syrup formula, KFC's original recipe. I know there's a lot of KFC knockoffs on the internet, people trying to make duplicate the original recipe, but it's not the original from KFC because they keep it as a trade secret. McDonald's Big Mac special sauce, and WD-40's multi-use product formula. Now, all of these are products or services that we use on a daily basis, but may have not thought that behind these brands, behind these products and services is a very valuable trade secret that allows the company to have a competitive advantage in the marketplace. Now, this is a busy slide, but there's 2 key takeaways that I want to point out on the slide without going into detail of everything on this slide. When do you use a patent, or when do you decide that I should seek a patent versus a trade secret? For patents, if it's possible to reverse engineer, if you have a long lead time to production and you desire to publicize your know-how, then you may want to seek a patent. Now, for trade secrets, if it's impossible to reverse engineer, if you have imminent or immediate commercial use, and it's a long-term high security and the idea is not patentable, then you may want to maintain your invention as a trade secret and not publicly disclose it to the world via a patent. Now, trademark. A trademark is how customers recognize you in the marketplace and distinguish you from your competitors. The word trademark can refer to both trademarks and service marks. A trademark is used for goods, while a service mark is used for services. So what does trademarks allow you to do? It gives you the exclusive right to use your mark. It prevents competitors from using a mark that's the same as or very similar to yours. It identifies the source of your goods and services. It provides legal protection for your brand, and it helps you to guard against counterfeiting and fraud. Now, What is the term for a trademark? Really, a trademark can be kept indefinite, but the patent office requires you to go through certain formalities in order to maintain that trademark indefinitely. They require you to register the trademark, and that registration gives you a 10-year registration period. Now, however, when you get ready to renew your trademark, as I just mentioned, you can maintain indefinitely as long as you show that, one, you're using your mark in commerce, and two, that you file the required documents at the USPTO to show that you're using your mark in commerce. And then on every 10th anniversary, every 10 years, the owner has to submit to the US Patent and Trademark Office proof that the trademark is in use. And if you do that every 10 years, then you can maintain your trademark indefinitely. Now, what are the different types of trademarks? You have some that are considered strong and some that are considered weak. A strong trademark is a fanciful trademark. That's a trademark that came about from invented words that did not exist before the company or the brand attached its company or brand to those words. It's inherently distinctive and had no meaning before their use as a trademark. Have meaning in relation to their goods and services. Two key examples of a fanciful and very strong trademark is Clorox bleach and Google. What are arbitrary trademarks? Arbitrary trademarks are actual words that existed before the brand or the company identified itself with that word, but it had no association, or it has no association with the underlying goods or services. Unlike fanciful marks, an arbitrary mark is a real word. As I said, in fanciful, it was an invented word. And that word is such that there's no connection to the meaning. Now, if you look at the various type of arbitrary brands the examples I provided, the first one is Target. The word Target existed for eons, and it's identified as you shooting something and hitting a particular target. Well, now, because of the consumer store or the department store Target, we associate a Target with that particular store and brand. Same with Apple. Apples have been around for centuries, but now we associate an Apple with the computer electronics company, Apple MacBooks, Apple phones. Apple was all over the world. And when we think Apple, we think the company or the brand Apple. The same with Domino's. Domino's is a game that's been around forever, but now we associate the word domino with the pizza company, Domino's. Suggestive marks. These are words that suggest some quality of the goods or services, but don't state that quality of the goods or services outright. They tell, they evoke, they imply, or they suggest a unique, distinctive characteristic. It requires some type of imagination in the mind of the customer to make that connection between the actual mark with the actual name or the brand, or in this case, Greyhound. Greyhound is an animal. But now when we associate Greyhound with the company, the bus company, we're now thinking, okay, I'm going to take Greyhound because it's going to get me from point A to point B in a very timely and expedient manner. It's like a Greyhound is a very fast animal that runs, that's raced, similar to a Jaguar. A Jaguar, when you think of a Jaguar, you think of a very powerful, very strong animal that has speed. Okay, now the company, Jaguar, the car company, has associated itself with that particular animal. And now when we think of a Jaguar car, we think of power, we think of speed, we think of something that's going to be beyond, what we're normally used to. The fourth type of trademark is considered a descriptive trademark. It describes some aspect of your goods or services without identifying or distinguishing the source of those goods or services. It has a secondary meaning, and that secondary meaning occurs when customers come to recognize the particular term as having a second meaning signifying a particular brand. Now, if you think of the term Best Buy, when you go into a grocery store, you want to get the best buy, the best bang for your buck. When you go to a clothing store, you want to get the best buy. But now because the retail, the electronics and computer store has associated its brand with the term Best Buy. Now when we think of Best Buy, we think of, hey, let's go to the store Best Buy because they have the best buys in terms of computers, in terms of phones, in terms of headphones, or whatever you need in the electronic space. Same with Honey Bake. Honey Bake that term has been around for a long time. And now, because the Honey Bake Company and the very tasty Honey Bake hams and Honey Bake turkeys that we buy for holidays, we now associate that term, which has a secondary meaning now because it was used over time by the Honey Bake Company. We now associate the Honey Bake Company with that term. And then the final and probably the weakest type of mark that you would never ever receive a trademark on is considered a generic mark. A generic term is a word that designates that type of product rather than the origin, the quality of one of that type of product. So aspirin, you go to the drugstore, you're going to see aspirin everywhere. It's just a very common term. You go to the grocery store and see milk. You're going to see various brands, various types of milk, as well as going to a paint store. So you'll never ever be able to receive a trademark on these generic terms like aspirin, milk, or paint, and there's many, many others. Copyrights. As I mentioned before, in order to receive a copyright, there are three main requirements. It must be original and creative, and it must be fixated into a tangible medium, and it must be a work of authorship. So what does that mean to be fixated into a tangible medium? An idea that you have cannot be considered a copyright unless you take that idea and turn it into a book, you take that idea and turn it into a record, you take that idea and turn it into a play, you take that idea and turn it into some type of performance. Now you have an idea, an original idea that has been fixated into a tangible medium of expression, and now you can say, I have a copyright. What is the term for having a copyright? For works created after January 1st, 1978, copyright protection lasts for the life of the author plus an additional 70 years. If a work is a joint work with multiple authors, the term lasts for 70 years after the last surviving author's death. For an anonymous work, a pseudonymous work, or a work made for hire, the copyright endures for a term of 95 years from the year of its first publication, or a term of 120 years from the year of its creation, whichever expires first. A copyright provides the owner with the exclusive right to, one, reproduce the work in copies of phonorecords, prepare derivative works based upon the work, distribute copies of phonorecords of the work to the public by sale or other transfer of ownership, perform the work publicly if it's a literary, musical, dramatic, or choreographic work, etc. Display the work publicly if it's a literary, musical, dramatic, or choreographic work, and then perform the work publicly by means of a digital audio transmission if the work is a sound recording. What's not protected by a copyright? Well, I just mentioned to you that an idea is not protected by a copyright unless it's fixated into a tangible medium. Titles, names, short phrases, and slogans are not considered copyrights. Familiar symbols or designs, mere variations of typographic ornamentation, lettering, and coloring. And yes, your grandmother's famous recipe for barbecue fried chicken, those ingredients cannot be copyrighted. You want to keep that as a trade secret and enjoy it for the rest of your life. Navigating the disclosure process. This is probably, I want to say, the most important section because it lays out and set forth how you should disclose your invention internally. And when I say internally, within the university context to your technology transfer office, and then how you should and should not disclose your invention publicly. An invention disclosure, also called an innovation disclosure, is a document that provides a detailed description of the invention. It's typically prepared by the inventor and sometimes with the aid of the technology transfer office. It's submitted to the technology transfer office and is the foundation of the patent application. An invention disclosure is not a patent application. It's not a dissertation or journal article, and it's not a public disclosure. According to the University of Louisiana System Intellectual Property and Shared Royalties Policy and Procedures Memorandum, disclosure is defined as all intellectual property in which the institution has an ownership interest under the provisions of this policy and that has the potential to be brought into practical use for public benefit or for which disclosure is required by law or agreement shall be reported promptly in writing by the creator to the designated institution officer or representative. The disclosure shall constitute a full and complete disclosure of the subject matter of the discovery or development and identify all persons participating therein. This next slide is going to get a little bit more in depth about what you should disclose and how you should disclose. I've been in this field for, like I said, close to 25 plus years. So I've seen and created many invention disclosure forms. And I know there's certain elements that I look for, there's certain elements that patent attorneys and patent agents look for in terms of information that they receive from you that helps them to write a solid patent application that will enable them to secure a patent application for you at the Patent and Trademark Office. Now, each institution, each organization, each company is different. They may have more elements on their invention disclosure form, and there may be less elements on their invention disclosure form. But based on what I've seen over my career, these are the primary elements that you want to include in your invention disclosure form to give the patent attorney and the patent agent enough information to secure a solid, strong patent application for you. Of course, you want to have the title. And then you want to list the inventors. You definitely want to give the description. If you have any drawings or diagrams, you want to include those as well. So what stage of development are you in terms of your research within the lab? Are there any commercial applications that you think that your invention could potentially fall into? It could be in one industry, it could be in multiple industries, it could be in biotech, it could be in electronics, it could be in any industry that you think that a potential commercial application can be derived from. Are you receiving any type of government funding? That information is important because in the first paragraph on the patent application, they have to include that this particular invention was funded by a particular agency of the government. Public disclosures. Hopefully you haven't disclosed publicly, and we're going to get into that in the next few slides. Hopefully you didn't disclose publicly, but if you did, you need to make the patent attorney and your technology transfer office aware of any public disclosures that you may have made with this invention. Patent references. If you can identify any references that are out there that may be similar to yours or that your invention may potentially infringe upon, you want to identify those. Any co-inventors or collaborators. You may be working with someone within your university or within other, or partner with someone at another university. You want to include those as well. Prior art. As I mentioned earlier, prior art is just not patent references. It can include journals, articles, magazines, books, whatever type of information that your invention could potentially infringe upon, you want to include that if you're aware of it. Confidentiality agreement. Are you on any type of agreement with your research that needs to be disclosed to the Technology Transfer Office? Any materials or methods, certain materials or methods that are unique to your invention that the patent attorney should be aware of? What about experimental results? Where are you in terms of your research? Have you tested anything? Have you tested your invention? To determine that certain results exist, you want to include those in your invention disclosure form. And then challenges. What challenges is your invention solving? And by having this invention, you're going to solve those challenges. So you want to include that as well. And the key takeaway here, submitting an invention disclosure to the Technology Transfer Office does not mean the application was filed at the Patent Office. To disclose the invention publicly before a filing occurs could potentially cause the university to lose certain patent rights. This is very important and a very key takeaway that I would like for you all to remember beyond this presentation. So what is a public disclosure? Under patent law, public disclosure is any non-confidential communication of an idea or invention. According to 35 U.S.C. 102, a person shall be entitled to a patent unless the claimed invention was patented describing the printed publication or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention. The U.S. patent law provides a grace period that gives an inventor 1 year to file a patent application after disclosing the invention to the public. But wait a minute, you just said that I should file before I disclose, and if I don't file before I disclose, I could lose patent rights. But now you're telling me I have a 1 year grace period. Well, the U.S. allows a 1 year grace period. However, other countries, as a matter of fact, 99% of the other countries in the world have what is called an absolute novelty right, meaning if you disclose before you file, you can lose the ability to file a patent application in those countries to protect your invention. And patents are very territorial, meaning just because you file a patent and get a patent in the US, it does not protect you in Japan, China, or any other country. You have to go into those countries and file in those particular countries. And if you disclose publicly in the US, you will potentially lose rights to go into those countries because those countries require you to file before you disclose. So what are considered public disclosures? Public presentation, poster session, department or campus seminar, online information posting, publicly available funded grant proposal abstract, filing of a provisional patent application without filing a corresponding utility patent within 1 year after the provisional filing, public release of an academic publication, digital or print, public release of an abstract, master's thesis, PhD dissertation, or open thesis defense, and then posters, abstract, and proceedings. All of these are considered public disclosures. So here are some common examples of public disclosures. As I just mentioned, submitted manuscripts and online publications. As a general rule, manuscripts submitted to peer-reviewed journals are treated with confidentiality, and the journal's editors, confidentiality by the journal's editors and reviewers. I don't know if I'm moving this piece to the side around because it's kind of blocking some of the text. So hopefully it's not showing up in the presentation. A submitted manuscript becomes a printed publication available to the public as soon as it's either published in print by the journal or made available online. Therefore, it's important that you understand the particular dates of both the online and printed publication, and you make sure that you're filing prior to the publication of those particular manuscripts or publication that you may have. A thesis and dissertation. A thesis or dissertation is generally sufficiently accessible to the public to constitute prior art as a printed publication once it's indexed and shelved in the library. So a key takeaway here, make sure that you file at the patent office before that thesis or dissertation of the invention is indexed and shelved in the library, because when it is shelved and indexed, it is considered a public disclosure. Scientific meetings. Attendees that want to present a poster or oral presentation, typically those oral presentations or posters are compiled by the meeting administrators or meeting officials, and they compile those posters and presentations into some type of volume, and they send that volume out to attendees maybe 1 or 2 months or 1 or 2 weeks before the actual conference. Well, that is considered a printed publication. Discussions with industry or potential investors. The key point here is if a confidential disclosure agreement is executed with the non-university party, then the disclosure generally is no longer considered a public disclosure for patent purposes. So in essence, before you speak with anyone outside of the university, 1, you want to first converse with your technology transfer office. 2, they probably more than likely would recommend that you set up a non-disclosure agreement or develop a non-disclosure agreement before you start speaking to them, especially exposing any kind of invention details that you may have. Electronic publication. This can be an online database or internet publication. If it's accessible to the public, it's considered a printed publication. And then grant application. As long as the grant application remains confidential, then it's not considered public disclosure. However, when that grant application is funded, that abstract is made available to the public, and the rest of the funded application can be requested by the public under the Freedom of Information Act. It is considered a public disclosure. Now, the next section I want to talk about is inventorship versus ownership. In this section, I want to cover what is inventorship, and then what constitutes ownership. Inventorship is a legal concept. It refers to those individuals who have made a significant intellectual contribution to the conception of the ideas that form an invention. What's the criteria for determining inventorship? One, conception of the invention. Conception is complete only when the idea is so clearly defined in the inventor's mind that only ordinary skill would be necessary to reduce the invention to practice without extensive research or experimentation. Contribution to the claimed invention. The individual must have contributed to the conception of the invention as it is claimed in the patent. Now I'll go into that a little bit more in the next slide. What are considered joint inventors? So the key takeaway here with joint inventors are, just because you work in different labs, you may work in one physical space and the other inventor may work in a different physical space, even at a different university, you're still considered a joint inventor if both of you all have helped conceive the invention and you contributed to the claimed invention. What if you didn't have the same type of contribution? Maybe I created one claim that went into that invention, and you may have created 10. We are still considered joint inventors. And then what if my contribution to your claim, or I didn't make a contribution to your claim, and I didn't make a contribution to my co-inventor's claim? Both of us are still considered joint inventors. Now, what's not considered inventorship? An individual who merely suggests an idea without the means of accomplishing the task is not a contributor to the conception of the invention. An individual who has simply followed the instructions of another is not a contributor to the conception of the invention. Simply providing the workspace tools or hands-on help in the actual construction of the invention does not constitute inventorship. Financing an invention, providing the physical laboratory space where the research is done, managing a research team, does not make someone an inventor. Serving in an advisory or supervisory role does not make someone an inventor unless they contribute intellectually to the invention's concept. The collection of experimental data, routine analysis. You may hire someone in your lab to collect experimental data, or to perform some type of analysis for you. That person does not qualify as an inventor unless that analysis leads to an inventive concept or the identification of a previously unrecognized property or use. And finally, refining an invention, such as optimizing conditions or scale up, does not constitute inventorship unless such optimization results in a new inventive concept. I can remember in my role at Saudi Aramco in the Middle East, this was a major issue because we had many supervisors that were just attaching their names to invention, primarily because it was incentive involved. Promotions were attached to how many inventions you created within your particular department. And then if you actually received a patent, the company would give the inventors $2,000. So in order to mitigate this problem, we had to create an ethics policy to really define who is an inventor and who should and should not put their names on invention disclosure, because they did not know that just because you put your name on disclosure, yes, you could probably get away with it within the company. But if the patent office finds out, they can invalidate that patent and you just lose all rights. If you put your name on the invention and you knew you did not have any type of contribution to that invention or to the claimed invention. Something to keep in mind. What constitutes ownership? Patent ownership in the US begins with the inventors. The inventors are presumed to have conceived the invention and therefore own the invention. A university becomes owner of the invention when an inventor assigns his or her rights over to the university, through a written contract called the employment agreement at the time of hiring, or through an assignment agreement at the time of filing. The university employment agreement or other contract allowing someone to do research at the university should be the first contract that transfers ownership to the university, and is very important. Who are considered co-owners? If the inventor or co-applicant contributed to the conception of at least one claim, and we touched on that, they will have equal and undivided interest in the entire patent. What does this mean? This means that they can sell the patent invention without having to pay anything to the other co-owner or co-inventor. So if one co-owner grants a license to a company without the consent of the other co-owners, and without having to give the other co-owners a share of the license royalty, they are within their rights. Non-employees such as visiting scientists, students, or fellows performing research with faculty may end up being joint inventors with university employees and should be required to execute agreements transferring ownership of any resulting inventions to the university. So the key takeaway here, make sure you have some type of agreement in place that will allow the university to receive full rights of that invention if it is created or developed on his university campus or within his labs or anywhere in the university, and the university is providing resources or is paying that researcher or that professor or whomever to do the work. Shop rights. These are various types of ownership rights. Even if the university does not own a patent, it might retain the right to use an invention created by an employee using university resources. Well, like I just mentioned, this can be avoided if you have an agreement in place that specifies and designates who owns what. Hired to invent. The university may hire an individual such as a faculty member or researcher to create or invent something regarding a specific type of technology or specific area. Well, the university will own the rights to that. And then work for hire. It applies when an employee creates a copyrightable work as part of their employment, or when a specific work is commissioned under certain conditions. The university will own the rights to that as well. This next slide, I'm not going to go into it because I'm kind of running out of time, but it just breaks down a comparison chart between what are shop rights, hire to invent, and work for hire. And I just kind of touched on the key elements of each of those in the previous slide, so I'm not going to go into this slide, but it will be available for people that want to view it after the presentation. Understanding technology transfer. In this section, I want to talk about what is technology transfer, what's the technology transfer process, and then what are the federal regulations that govern technology transfer within the university setting. Technology transfer refers to the formal process of transferring scientific findings from one organization to another for the purpose of further development and commercialization. Universities, particularly public institutions, have a core mission to contribute to the public good or public benefit. University technology transfer is a crucial mechanism which universities fulfill these commitments by ensuring that scientific and technological innovations derived from a university's research are transformed into new products, services, applications, or processes that will ultimately make their way into the wider world, again, for the public benefit. So what is the technology transfer process? Of course, this differs from institution to institution, from company to company, but based on what I've seen over my 25-year career, these are the key elements or the key elements that define the technology transfer process. And of course, the first one being research and development. Researchers at the university create the new invention or discovery. They then disclose that invention to the technology transfer office. Thirdly, the technology transfer office receives that invention disclosure. They make an assessment on the commercial potential, the marketability, the patentability, and potential licensees that they can reach out to. Protection. Once they determine that this invention has commercial potential, they then reach out to a patent attorney or patent agent to now start the whole patent application / filing process. Marketing. The Technology Transfer Office is now, once they know they have something that has potential, they're going to market it to potential licensees, someone who has a deeper pocket that can pick up the tab to actually bring this invention to the marketplace. And then once they identify potential licensee, they're going to enter into a license agreement with that company or institution. And the license agreement should have, it's very important, strict diligence provisions to enable universities to enforce the agreement. This is very important because it allows universities to be able to step in if they deem that something is not right, if the licensee is not actually doing what they say that they would do in terms of getting the invention out there to the marketplace. These strict diligence provisions will allow them to step in and enforce that agreement. Then commercialization. If the licensee that you engage actually takes that invention to the marketplace and commercialize it, the next step is revenue. The company will pay royalties to the university according to the terms of the licensing agreement. These revenues can be reinvested back into research and education at the university, and they can cover the administrative costs of technology transfer. So what is the Bayh-Dole Act? The federal regulations that actually govern technology transfer. Well, Bayh-Dole allows universities, small businesses, and nonprofits to retain intellectual property rights to inventions developed from federally funded research. According to 35 U.S.C. 200, policy and objective of the Bayh-Dole Act, Congress is to use the patent system to, one, to promote the utilization of inventions arising from federally supported research or development, to encourage maximum participation of small business firms in federally supported research and development efforts, to promote collaboration between commercial concerns and nonprofit organizations, including universities, to ensure that inventions made by nonprofit organizations and small business firms are used in a manner to promote free competition and enterprise without unduly encumbering future research and discovery, to promote the commercialization and public availability of inventions made in the United States by United States industry and labor, and to ensure that the government obtains sufficient rights in federally supported inventions to meet the needs of the government and to protect the public against non-use and unreasonable use of inventions. And finally, to minimize the cost of administering policies in this area. Now, what are some key Bayh-Dole provisions? Ownership by universities. Universities that receive federal funding can elect to retain title to any inventions resulting from the research. Duty to disclose. The university has a duty to disclose the invention promptly, to the federal agency that provided funding. Government rights. The government has a non-exclusive, non-transferable, irrevocable, paid-up license to use the invention. March-in rights. The government can require the university or other owner of the patent to license the invention to others. These rights are typically invoked when the invention is not being made available to the public on a reasonable basis. Preference for U.S. industry. This requires, the government requires that it gives preference to companies that will manufacture the product substantially in the U.S. Inventors' rights. If the university chooses not to retain title to the invention, the inventors may be able to retain the rights themselves and then exploit it as they see fit. Then income and royalties. Bayh-Dole requires the university to share royalties with the inventor. And finally, these are some of the key takeaways that I would like to leave with you all as it relates to intellectual property and technology transfer. Universities can protect and monetize their research through a clear understanding and management IP rights. Bayh-Dole incentivizes the commercialization of federally funded research, field and innovation, and economic growth. Understanding IP rights and Bayh-Dole requirements are crucial in the technology transfer process, including invention disclosures, determination of inventorship and ownership, public disclosure, patent filing, and marketing to potential licensees. Balancing various interests such as conflict of interest, publication policies, and licensing negotiations can be challenging, but it's integral to the successful implementation of technology transfer. And last but not least, technology transfer is a rewarding process that converts academic research into real-world applications and drives economic development for the public benefit. This concludes my presentation. And are there any questions?
Thank you so much, Attorney Green. You have provided us with a high-level overview of university, ranging from university patents to how to set up a tech transfer office. I just want to, I was listening, and I have a little familiarity with this field, and I say little, you're the guru. And I just want to I have some takeaways. So with some schools in our University of Louisiana system being primarily teaching institution, based on your experience, what would you suggest at a minimum for a primary teaching institution to have if their sponsored programs office or some similar office is tasked with handling the IP technology transfer at that institution?
That's a great question. I think it's a very important question because you never know when IP is going to be generated or when you're going to conceive an invention. And if there's no resource available for you to disclose that invention or that patent, that particular concept that you have, then you're basically losing, could be a valuable idea or a valuable patent that you know probably attain down the road. So what I recommend in that instance, if the Office of Sponsored Programs, if they have the budget, if they can hire at least one person who has some type of expertise that can understand about invention disclosures and how to, disclose that invention and possibly provide some type of training, that would be extremely helpful. If that's not possible, because you have a University of Louisiana system, you may have universities that can partner with each other, and they can probably share the benefits of that invention that comes from that university that does not have a fully functioning technology transfer office or any type of resources available. I would rather you share that invention with another university who has the resources rather than just letting the idea just go to waste. So if that university, if that's not a focus of that university to set up any type of technology transfer component, they must understand that inventions and ideas can come from anyone at any time. And it needs to be some type of pathway that professor, teacher, researcher, or what have you can utilize in order to get that invention disclosed. And that pathway could be another university within the University of Louisiana system.
As a follow-up to that question, and I think you hit on this follow-up, with funds being limited to schools in the state of Louisiana and to schools across the United States, such as primary teaching institutions whose main focus isn't on the research. What model have you seen in your career? Because your career, you've worked on the university side, you've worked private industry, you've worked with the federal government. What models have you seen employed by smaller institutions? For example, should several schools get together and share a patent office or hiring a patent firm, or should schools go about it individually and maybe hire someone on a retainer basis? What models have you seen, and or what would you should suggest for primary teaching institutions?
I've seen both models that you just alluded to, but I think in this instance, I think it's best for universities to combine their efforts, to combine those talents, to combine those resources. Because again, the benefit, yes, you may have to share resources with another university, but I would rather share resources with that other university or share the benefits of my invention with another university rather than just letting that invention, potential invention, just die in my mind, because we don't have the capability at my institution to actually, to allow me to disclose that invention to someone who can then take it and work with someone outside to prepare application and get it filed. So in that case, I think the best case scenario is for schools within the institution, within the University of Louisiana system, to partner together, you may even have a situation where one school can focus on a certain area. Another school can focus on a certain area. Now you have those two schools that are combined. And now you have multiple adjacent industries that you could potentially look at with that invention, because they focus on a certain type of research or a certain area of innovation or technology. And this school has focused on a certain area of technology. And when you combine those, now you have multiple options in order to consider, and not just one particular pathway. So a short answer to your question, I think the university should combine their efforts, combine their resources, and work in tandem, work in partnership, and move down that pathway together.
That's a good point. Good idea. We'll have to present that to the system. Very good idea. Another question, our observation. The section on disclosures is quite important to our faculty researchers and to our research graduate students. Have you found in your work that universities generate a high volume of patents or submit a high number of patent applications to the USPTO, such as the University of Florida had the Gatorade big discovery, and we know how lucrative that is for them. And I know Florida State University has a high volume of patents. Those are research institutions, but just in general, in your experience working with the United States Patent and Trademark Office, you may have some knowledge about the volume of patents generated by institutions of higher education.
Well, to be honest, there's a lot of technology that kind of just sit on the shelf, to be honest with you, because it's so expensive to file a full-scale patent application. And when I say full-scale patent application, I mean a non-provisional patent application with the drawings, with the specification, with everything that's required. Now, what I have seen is that some universities, as a strategy, not only universities, but I've seen this with companies as well, because I've utilized this strategy as well to file a provisional application. A provisional application is a very scaled down application, which only allows you to file a specification and then a cover letter. You don't have to file claims or anything like that. And for a provisional application, only costs between $1,000 to $2,000. Now, with a provisional application, you have 1 year to convert that application to a non-provisional application. So what it does, it gives the university or the company a 1 year period to try to find investors or someone that can pick up the tab of that non-provisional application and then get it filed. But to answer your question, because universities don't have a lot of resources, they have to be very selective in the type of inventions that they want to move forward on and to get patents on, because of the fact that it costs so much to get a patent application filed, unless they utilize the provisional strategy. But even with that strategy, you have to be careful, because if you disclose something today as in a provisional, then come back a year later and try to disclose something that you did not disclose in the specification before, you cannot get the benefit of that earlier filing date. And that's one of the benefits of filing a provisional application, because you file today, I get a filing date today. Then I come back a year later and file my full-scale non-provisional application. But guess what? The filing date for that non-provisional is the same as the provisional. So if anyone in between that 1 year time, for however they did it, they filed the exact same provisional application or the exact same thing that you filed as a provisional, you now can come back and claim the earlier filing date with that provisional and invalidate their application and their potential invention. But universities don't really have a lot of resources, and you find that they cherry pick a lot of the type of innovations and inventions that come out of the university because of the resources, because of the lack of resources. This is why it's important that you can combine your efforts with other universities within the system. You have more resources. Now you can be more strategic in the type of applications you file, and it helps to one, preserve resources, but at the same time, it don't leave valuable ideas or conceptions on the table, if that answers your question.
It does. Also, I've heard some people say that this is a question about copyrights. Is it correct or is it true that for a copyright, some people say, well, if I just put that circle with the R in it or what have you, then my work is covered?
Yes, you don't have to actually register a copyright at the patent office. I mean, excuse me, at the copyright office.
Okay.
Once you fix that idea into a tangible medium, at that point, it's considered copywritten.
Okay.
Now, the benefit of registering your copyright, say someone actually takes your copyright, infringes your copyright and attempts to use it. At that point, you're going to have to register your copyright in order to go after them legally. But yes, if you want to just put you don't even have to put your copyright symbol on there. But if you want to just put the copyright symbol on your work to put people on notice, you can do that, but it's not required by the Copyright Office in order for you to have a copyright. Once that idea becomes something that's fixated into a tangible medium, at that point, you have a copyright.
Okay. Here at Southeastern, we have a student creative and scholarly showcase day, and they do poster presentations for the most part, the students in the sciences. What happens if I do a poster presentation? I have no clue I have something that's patentable. And then maybe 2 years, well, I'm in my senior year or my first year of graduate school, we do a little more research and I say, oh, I have something patentable. But I presented this 3 years ago at the student showcase.
Yeah.
What happens with that?
Well, you could potentially lose the right to file that application because, as I mentioned to you, the U.S. has a 1-year grace period. And if you say 3 years, 2 years out, you could potentially lose the right to file that application because you publicly disclosed that that presentation or that poster in a conference and you wasn't aware of it. However, if I can go to this slide, give me a second, because I just didn't cover it in the slide. Do we have a little time? I want to find this slide because I think this is important. Let me go up here. Okay, here we go.
Okay.
I think it's not this one. It's this one. Okay. Attendees that want to present either a poster or oral presentation often submit their abstract ahead of the meeting, which is then compiled into a volume that is typically made available. Okay, I touched on this.
Right.
But what I didn't include is that down here, I have in my notes, a poster presentation can be considered a printed publication under 35 USC 102. Whether a temporarily displayed reference that was neither distributed nor indexed, i.e. a poster, is sufficiently publicly accessible to count as a printed publication depend on the following factors: the length of time the display was exhibited, the expertise of the target audience, and 3, the existence of reasonable expectations that the material displayed would not be copied. And there's a 4th one: the simplicity of ease with which the material displayed could have been copied. All of these factors relate to the ability of the audience to copy and or retain the displayed material. According to the Federal Circuit, the duration of the display is important in determining the opportunity of the public in capturing, processing, and retaining the information conveyed by the reference. So it's a case-by-case basis.
Okay.
They're going to look at how long was the poster actually displayed. Number one, they're going to look at the expertise of the audience. If that poster that was displayed in the audience has an expertise to know that, you know, that particular poster may have some inventive concept, then it could potentially invalidate your ability to file a patent application down the road. So there's certain factors that the court will look at. They look at this on a case-by-case basis. But I kind of knew that this was going to come up. That's why I put this in my notes.
Yes, very good. Thank you. Yes, because we do this every year. And
Mhm.
usually the posters is displayed for about 4 hours, 4 to 5 hours.
Mhm.
And other students come through and look at the displays because we do creative arts also. So it's students
Yeah.
that come and look at the various displays, faculty advisors.
Mhm.
So yeah, I thought that was kind of important to point out.
Yeah, like I said, it's case-by-case basis. But, you know, hindsight, I mean, to be on the safe side or err on the side of caution, however you want to say it, is always best. If you think you have some type of inventive concept, you want to run it by your technology transfer office before, or someone who knows whether or not this has some type of inventive concept to it before you actually disclose it, because you may lose rights down the road.
Okay, and I have one last observation or question. What happens, and I think you touched on this, what happens after a patent expires? We've had some patents here at Southeastern, and I'm sure other schools in the UL system have had some patents, and this is just for our self-knowledge, the people on the webinar and the people that will review it afterward. What happens when your patent expires? I know you pay at certain periods. You pay at the 8-year mark, the this year mark, and the that year mark, and then all of a sudden it's over. So what happens when it's air quote over?
So you just touched on it. It's 3.5, 7.5, and 11.5 years. Those are your the years that you would have to pay to keep your patent active at the patent office. Once you hit the 20-year mark, it becomes public disclosure, public knowledge. Anyone can take that invention and then use it. They can take it and potentially add on to it. They can even add on to it while it's considered active. However, if you're using any of the elements within that particular patent, you're gonna have to definitely deal with or talk to the original patent owner. But once that patent expires, it's kind of free game. Now in the biotech pharmaceutical industry, you know, generic patents come about all the time, or generic drugs come about all the time. That's because that patent application has expired. But what a lot of savvy biotech and pharma companies do, they have some type of extension that they can file. I'm not 100% certain the type of paperwork they can file to kind of prolong the life of that patent, because, you know, it's a drug that's being used in the marketplace to prevent the generic companies from stepping in and using that technology. But yes, 20 years is considered for public consumption, and anyone can take it and utilize it and do what they will. Yeah.
So it's no such thing as reinscribing or redoing anything. It's just out there.
Once after 20 years, yeah. Well, like I said, there's for the biotech pharma industry, I need to check on that and to be specific. I know they have some creative things that they do in terms of trying to prolong that patent. But exactly what, I can't really speak to that right now.
Thank you so much. Well, that concludes all the questions that are in the Q&A and in the chat. I want to thank Attorney Green for his time, his talent, and his intellect, and his wealth of experience, and his knowledge about patents, from the beginning to the end and setting up a technology transfer office. Thank you so much for your time, as I said, and we look forward to those persons to view this on our YouTube site. And again, thank you and have a good day.
Thank you. Thank you for having me.
You're welcome.
All right.